hit record. We would like to welcome Amanda Lutz, who is going to do our lawyer review mastermind session for us. And then if anybody has any questions at the end, please feel free to ask those. That's a big part of what this is just very interactive sessions to be able to help share the knowledge and information that we have and to raise the bar. No pun intended on having a lawyer here. Sorry. I really did not mean that. All right, Amanda, do you want to take it away?
Sure. Can everyone hear me okay? Yeah, okay. I'm going to keep my video off for now because when I put my video on, I tend to lose signal. So I want you to be able to hear me. So my apologies, you won't see my lovely face. I look very wonderful right now. So my name is Amanda Lutz. I'm a lawyer with Kennedy Schofield Lutz Lawyers. We're out in St. Margaret's Bay. So I practice primarily in real estate law, which is obviously why you're here. But I also do wills and estates and corporate work. And some of that can inform some of what I do as well on the real estate side. So I was invited today with a specific question in mind. So what I was asked is, what is the lawyer review clause? And in particular, what sort of things can you spot before getting to lawyer review that might save you time with deals? So the first thing I want to do is I want to distinguish two factors of my role. So there's lawyer review and there's title review. So lawyer review is really about the contract itself. It's not looking necessarily to see, did you fill it out right? Yes, we're going to look and see that. But it's actually more about, is this the way you've structured it, is it going to work for the client? So some of the things I might look at in particular are going to be your HST clause. How has the client actually been using the property? And is there a potential risk here that HST actually does apply? And have they answered it right if HST is supposed to apply? And what does the client understand? So that's probably one of the biggest ones that I'm often raising is HST, especially with Airbnb. That's a big flag for HST. To anyone who wasn't aware of that, is that Airbnb, depending on the nature and length of use, could trigger HST. Now, I'm not an accountant, so once I see that, I send clients to an accountant to determine their next steps. But that's an example of something that I'm looking for. So lawyer review is more about the contract itself. Is it what the client understood? And especially I'll look at the unique clauses that you'll write. So the standard realtor forms are pretty straightforward, but if you start to add additional clauses, is it clear? What is it that we're trying to say? So those are kind of the big 2 points on the lawyer review side. Now for myself, when I do my lawyer review, I also hit on the title review side of the world. So title review is going to look more at exact title of the property. So we're going to look at what easements are there, what restrictive covenants are there, do we have the access to the property correct on title? And if it's not correct, how do we fix it? And we look at judgments in the names of the sellers and the purchasers as well, which could be an issue. So that's the title side of the world. And that's also where you can find deals have issues. So I like to do them at the very beginning. So the last thing I want is something to firm up. And then, oh, and by the way, we're going to terminate now because of this title review issue. So I try to catch those early on. So that's kind of the distinction between lawyer and title review. And I just want to start with that because they are technically two separate things. And title review, I have a much longer period of time on than I do with lawyer review. But for myself, once I say it's firm from my end, then I've already done both in order to move forward on that. So some of the questions you want to think about when you're looking at the lawyer review side, though, is obviously filling out the form, which I know you guys all do, so that's not an issue, but making sure that you've entered all the details correctly the way the client understood, which seems straightforward, but from not this brokerage, from other brokerages, I've had problems where people might not fully fill out the form, and so we'll have to answer some of those questions. But HST, of course, being the number one issue. Some of those additional schedules can also form an issue. The multi-unit residence one is a good example, because sometimes there's a question on there that you say how many can be vacant on closing. But the way it's worded is a little bit misleading. So you have to sit down and make sure that is correct and that the client, that's what they actually were looking for, because maybe they want to be sure everything's rented. And if that's the case, you want to make sure it's worded correctly for that. So that's kind of the main lawyer review. But when I talk to my clients, I'm also on lawyer review looking at what's their personal circumstances. So they're getting a mortgage. Have they verified they can get insurance on the property, which seems like something would be automatic, but a lot of my deals are coming in without an insurance clause. Well, you can't get a mortgage without insurance. So we want to be sure that's something that you can actually get. But we also want to look at their personal side, like what's their residency status, what's their citizenship like, and is there going to be a tax consequence to what they're doing? I also will raise some items on lawyer review on the side of if the client wants to assign it to their company, for example. But those items tend to not be things that are going to turf a deal. They tend to be things that the other side is not going to care. You want Joe Blow's Pizza Shop to buy this? By all means, have Joe Blow's Pizza Shop buy the property. But it's still something to be looked at. So those are kind of the main items you can kind of be looking for. I could hammer home the HST, but it's probably the biggest thing I raise in lawyer review. But also those additional schedules, and did the client understand all the things they should check? A vacant land purchase has got to be one of the ones that I raise the most objections on, because people think, oh no, I'll be able to build it. The seller told me so. Well, that doesn't actually get you that far, because you might not be able to get the permit for the septic. You might not be able to get water, the quality you're looking for. Like, there's so many things, as I'm sure you all know, that should be checked before you're building. So really that's what, it's that second look at, was there anything that should have been looked at? And ultimately, the thing you have to remember about lawyer review is it can actually be your best friend, surprisingly, because it's one of the strongest clauses to use to terminate a deal. But it's also a clause I try very hard not to use to terminate a deal, because I want to save it in my back pocket for when I absolutely need it. So technically speaking, and please don't use it this way, I can actually use lawyer review to add a financing clause. I can use lawyer review to add insurance, and it's possible. I've actually done so. I don't like it, but I have. So it's something that if a client really didn't quite understand what they were getting into, I can use to protect the client. And so that's what it comes down to. So it's one of those clauses you want right to the bitter end, so that if something weird doesn't really fit and another category comes up, you have the lawyer review on that side to be able to likely utilize, because the courts have interpreted it very broadly as to what it covers. So it covers so many different things. I couldn't even begin to tell you everything it could cover. I don't know if that answers the question you guys are looking for or not. Okay, well, no one's asking questions, so I'm going to go ahead and say that maybe answers your question, but I would like to encourage some questions if you guys have any. But on the title review side, something you can look for is when you go to the parcel register, you can look for things like, you can see your restrictive covenants there, but you can also see easements, and sometimes the easements dictate maintenance. So that's something clients aren't necessarily prepared for. They weren't understanding they were going to have to pay for road maintenance. So those are just a couple items you can look for on title. It'd be harder to explain to you how to look for judgments, but that's something else you could look for. And if anyone wanted me to explain it, I certainly would be happy to do so. Anyone have any questions, though, that they want to ask?
There is one question from someone who is not able to join, and it is not specific to title or taxes, but it's more related to condo documents. So her question is, I want to ask for condo documents. Would the lawyer check those annual meetings and the reserve fund study to ensure that the condo corp is under good management, or do they check the estoppel only?
That's actually a lawyer dependent question. So I do an overview review of them. So I don't do a very detailed one unless the client asks me to do so. Well, usually what I look for is, what's the reserve fund study asking for? What do the financial statements show me as to what's there? And why is there a discrepancy if there is one? I don't typically review the full condo document set, but I do tell clients to do so. And if clients have questions, I encourage them to ask. But it depends, because I know certainly there are lawyers who that's the only thing they look at is the estoppel certificate. And legally, there's a right under the estoppel certificate to raise objections. But again, it's back to the which way everyone approaches it. So My obligation doesn't technically require me to look at the reserve fund study and the financials, but from my standpoint, I think I'm not doing my client a service if I don't review it. So for myself, I would, but it's not an actual obligation. We just have to advise our clients that they should review it and what the risks are associated with it.
Okay. Okay, thank you.
No problem.
I have a few questions.
Sure.
Firstly, ideally, how much time do you want for your lawyer review, say on a standard 60-day close? Like what would be ideal for you? And secondly, does it matter if the closing is on a Friday or a Monday? Do you prefer a certain day? I know certain lawyers want to avoid Fridays for certain reasons.
Yeah, so in terms of timeline, I ask for a minimum of a week if at all possible. I've certainly turned them around in a day or less. Ideal world, I'd say 2 weeks. Really, the biggest thing that holds me up is getting in touch with the client, because I still have to review with the client what I'm seeing and make sure it matches what they understood. And it's sometimes difficult to get the client on the phone. So that's probably the hardest part of it, but I can do a lawyer review in a matter of hours. So I've done some where it came in, it had to be reviewed that day, and before 1 o'clock, I'd already reviewed it. So in terms of timeline, I'd say the ideal is 2 weeks. Might be longer if and only if it's crazy busy season like we had last year and the height of it all. But even then, I've turned them around faster. So ideal, I guess I'd ask for 2 if I'm lucky. As for closing on a Monday or Friday, well, the truth of the matter is I prefer to avoid Mondays and Fridays. I'll do them. I have no problem with it. But on a Friday, if there's any issues and we can't close by the end of the day, then we're pushing over the weekend, which means that a client who has their movers booked for a Saturday are going to be highly disappointed that they can't get into the property. So the other problem is, and this is an odd one, is that there are lawyers who don't like to work late days on a Friday, and so they're not there, which means how do I negotiate with a person who has left the building? So sometimes that can cause problems for clients. As for Monday, the only problem I have with Mondays is lenders. It seems like they don't wake up that early in the morning. So on Monday morning, sometimes they'll delay in providing me with the funds. But I don't actually mind Mondays. I prefer middle of the week, just from the standpoint of if there's anything I have to collect. Monday morning, I can go through my closings for the week and go, okay, this is what items I want to make sure I've got. So I'm ready to close. But if I'm going to close on a Monday, I'm doing that on Friday. So that's really not an issue from my standpoint. It's really the Fridays. And if it's a long weekend, then a Thursday, that kind of idea. The day right prior to a weekend is where I try to avoid.
Thank you.
No problem.
I have a question for you, please.
Sure.
I'm new to the industry and I've only done a few transactions, but I had a situation last fall and I had a seller. The seller chose a lawyer and we had everything all set up. Everything's moving ahead. We get to, I think it was the day before lawyer review. And I wasn't entirely sure what my I'd sent a number office on.
Sorry, you're breaking up a little there. I'm not quite catching you.
And the receptionist was a little taken aback, and then all of a sudden the and spent about almost 20 minutes. So what, maybe that's a question for everybody. What would my responsibilities usually be in a normal situation like that?
So sorry, David. I really couldn't catch everything you were saying. You were breaking up. And I'm sure you have a really good question, so I'd love to hear it. Is there any chance you could type it in the chat?
Sure, I'll try that in a minute. Go ahead with somebody else then.
Sure. Sorry, David.
That's okay.
Anyone else have a question in the meantime while David gets that in, or do you want me to wait?
Can you explain the difference between the HST for some buyers versus other buyers, if they're using it for Airbnb or if they're using it as a rental property, versus personal name, in their personal name or in a business name?
Yeah, so it's not so much about whether it's in their personal or business name. The question is whether it's being utilized in a business manner. But there's exceptions to that. So Airbnb is pretty clearly business when you think about the number of different people who are coming through. But it doesn't fit under the exception of like residential rents. So when you rent year to year, month to month, that style of rental, you're exempted, as I understand it, from HST applying, and it doesn't matter if it's in your company name or not. Now, one thing that can come in handy is if you've got a seller and a buyer who are both HST registrants and their use is going to be very similar, then you can have an option to agree to waive the HST, because effectively the seller would have had to collect and remit HST, and the purchaser would have had to pay it and then go back and collect it because it's an input tax credit, is my understanding. So there's an exemption there as well that could be used. But it's not so much about whether it's in a business name, because if they haven't used it in the nature of trade, it may not trigger it. But once I see that it's in a business name and they're not clear on how they've used it, I send them to an accountant, because it does go a bit beyond my expertise at that point in terms of what HST could apply. But for the most part, clients have really had the struggle around the Airbnb as the big thing, or if they've used it for their business. Does that answer your question?
Yeah, I know that there's been a lot of agents trying to figure out which sides they have, and it's always get them to talk to an accountant, is what I typically say. But I just thought it'd be something good to review in this section since we're recording it. Thank you.
Yeah, no problem. And yes, accountants are probably your best friend on that one, but you can't always get an answer. So I know enough to know some of the big triggers. And that's where I then send them to an accountant, because there are exceptions even with Airbnb, depending on how they've used the property. So sometimes if they've only done Airbnb for a week and the rest of the time they've used the property as their principal residence, it may not actually trigger it. It really would depend on their exact usage.
It's David again. I'm on my phone now. I don't know if you can hear me better.
I can hear you right now.
Definitely.
Give it a go.
Oh,
Yeah.
okay, good. I don't know how much you missed last time. I'll just try and abbreviate it and start from the beginning. But anyway, in the fall, new to the industry, and I had a transaction for a seller. It got to be the day before the lawyer review date, so I started emailing to follow up because nobody'd heard anything. The day of lawyer review, I called the office, and the receptionist was put off a little bit somehow, and all of a sudden the lawyer came on. The lawyer in question very nicely, but basically lectured me for about 20 minutes about how busy he was, and that he doesn't look at all the contracts. He only looks at them if I was to bring up an issue and say, I think there's something wrong. So I wasn't too sure what my role is with that at the time. I thought, well, I'm not a lawyer. How am I going to know if there's anything wrong with it? I've sent it off to have it checked. So I just kind of wonder what my role is as far as following up or anything like that. It just seemed like a really strange situation.
Yeah, I'm sorry to hear that happen, David. I do know there are lawyers who don't review their contracts. Legally speaking, I'm supposed to be reviewing the contracts. So if you send them to me, it's my role to review, not the other way around, because how would you know what I'm looking at? And I mean that nicely, because there are things I look at that you may not think to look at, and it's not your role necessarily to do that. So the lawyer is taking it upon themselves to decide it's not of concern. I don't want to speak ill of any other lawyer, but I do know that's not unheard of. For myself, I like to respond and tell my realtors when I've completed my end, which might annoy the living daylights out of you guys, because I'll email you first if I have concerns to see if there's information, because I don't want to stress my client out for nothing. So I'll raise it up to you first, and then I'll go to the other lawyer if you prefer. But that's kind of how I approach it. There are other lawyers who take it that if they say nothing, that means everything's fine. But then it sounds like you kind of have a third situation where the lawyer hasn't really looked at it, and that's unfortunate because it is part of our obligation to review the contract. And if there's an issue, we should be raising that at that point. There is a bit of information from our Barrister Society that indicates that even if we're past lawyer review, if a reasonable objection's made, even at that time, that it should be attempted to be met as long as it doesn't disadvantage our clients. I'll never use that because I just can't take that risk that it won't be reasonable on both sides. So I guess the long and short of that one is I'm sorry because that shouldn't have happened and they should have reviewed it. And I would hate to hear that that was a common occurrence. I'm hoping that was just that particular lawyer. And I know sometimes there are lawyers who don't really do real estate as their main area. And so maybe they didn't quite understand that. I'm going to hope that's the reason, but you shouldn't have been treated that way. I'm sorry, David.
Oh, that's okay. That's kind of what I thought. So basically for my role, then I should just be making sure there's some kind of correspondence. And I don't like to go with the no news is good news. And that's why I started calling, because I thought, just in case it's under a stack of papers or something, I'm going to help this person out to alert them that that needs to be done today. But so basically just following up is probably my best plan of action if something's going on.
That's how I would handle it. Lawyers can be faster to email though than phone, so it might be worth a quick email to them. I find I can respond to an email in between clients much faster than a phone call, so I'll miss those a little bit more often than an email. So maybe that would help, but certainly you could also send an email and say, if I haven't heard from you, I'm going to assume you've finished your review and you were satisfied. And at least that covers your back if there is any issues down the road, because you've made it clear to the lawyer what you're asking for. But I'm sure you did everything right in this case, and I'm just disappointed to hear about that other lawyer.
Okay, well, thanks.
If I can interject there, David, as an old agent, I've always worked with lawyers that do work with me, so I ask them straight out, do they review it? And two, I want confirmation when I send them in a contract, so I know they've received it and they can start working with it. And then I want them to tell me when the deal is done, so I can advise my clients that they now own a house. I don't want them calling me to tell me they're finished. I want to be able to call my client. So you should find some good lawyers out there that kind of will work with you and keep you abreast of what's going on.
Yeah, that's good advice. Some of the other, I've dealt with about 2 or maybe 3 other firms since then, and that's basically how things have happened. There's been emails back and forth and confirmation of receipt, and I thought that's probably the norm. So I just wanted to confirm my role in that. But yeah, that's all very helpful. Thanks.
Like agents, lawyers aren't all created equal either.
Very true, Michael, and you're very right. A lawyer should be responding to say they got it. They should let you know then they're done reviewing. They should let you know when everything's closed. And of course, thank you for your hard work, which is one of my number one things to do, because without you, it would be a lot more work. And I charge probably, 4 or 5 times my normal rate if I have to do a private sale, because I'm insistent on having a realtor on there.
That's good to know. I was actually asked a little while ago from a seller what the difference is like in a lawyer's fees if they went FSBO versus with an agent.
Yeah, that really depends on the lawyer, but our firm has taken the approach that we charge a substantial amount more because there is so much work that you guys do. And after one deal doing it, I realized the amount of hand-holding that would be required that I don't have the time to do. So if they're going to do it, they get my hourly rate of $250 an hour, and I track every single minute of time. So if you think about that for just a moment, that's going to charge them quite a lot. And frankly, that's what it should be, because I'm effectively doing the work that you would have been doing. And I want it to be very clear to them how much work you guys do.
I have a question. Someone on my team had wanted to know how you guys deal with dual, I guess not agency, but dual representation. So if for some reason the seller is being represented by your firm and then all of a sudden the buyer wants to also be represented.
Yeah, that's a good question, Angela. We do dual representation, but the one thing I won't do is I won't personally represent both sides. So, and we very clearly outlined to the parties that there is dual representation occurring at the very beginning. And we make sure that both parties agree and are willing to waive the right to confidentiality, because there's no guarantee. But we also make every effort internally not to share and to strongly advocate for our individual clients. But at the same time, for example, in my firm, the walls, you could probably hear them if you really wanted to, and we use a common printer. So it's quite possible that information can be unintentionally shared. Sometimes it can make things slightly smoother in the sense that I don't have to get a check out the door, the package doesn't have to get out the door, so I'm not standing around waiting for someone else's package to show up, because we're literally in the same office and I can just go knock on their door. But having said that, I am not a huge fan of dual representation in the grand scheme. But if a client's really insistent on it, then the firm does it that one lawyer represents one and the other lawyer would represent the other.
And what happens so we have been in a situation where both parties were like, no, absolutely not. That's my lawyer. We're using it regardless. So, and we've had both buyer and seller use the lawyer or the lawyer's office, and everything seems to be fine. And as we know, as realtors and you guys as lawyers, that everything's dandy until, pardon my language, shit hits the fan. So, you know, in a situation like that, where does your firm stand on, you know, you guys taking care of it until a problem comes up? Because an issue that we had in the past was the lawyer's office was like, yeah, we do dual representation, you know, we'll talk to both clients, we'll let them know. And then all of a sudden it comes down to the end and there's a problem. And the lawyer says, oh, you have to find new representation because this is conflict of interest.
So I guess that depends. Depends on what the nature of it is. Part of what they agree to when we tell them about dual representation is if there is a conflict and the firm bows out. Having said that, we've had some conflicts that are technically conflicts, but there's something that can be resolved. And if it's something that we can work through, we're going to work through an issue. No different than you do your closing day walkthrough. There's too much garbage in the property and two lawyers are going to banter about for the rest of the day on how much that's worth. And in those cases, that is something we can certainly handle internally. I'm sure we can come to a resolution. It depends on how substantial the conflict is. And if the conflict is substantial enough, then it is our obligation to advise, and typically at that point to bow out. But I haven't actually had that happen yet. Any issues that I have had come up thus far, we've been able to work out. So it really just depends, I guess, on the issue itself. And without knowing the specifics, it's hard for me to say how we would have handled that. But our firm is pretty good at being reasonable, I guess the best way to put it, and trying to come to an amicable solution wherever possible.
Anyone else have any questions, or should I just keep going? Okay.
Keep going.
Okay.
Keep going.
So something that's kind of not personal, well, I guess within the years that we've done real estate, is we find that while we do the transaction and then we send it off to the lawyer and then everything's going along and then closing day comes and everything seems fine, and then we close and within a day, 2 days, something big has come up, and you know, it goes against maybe what the PDS has said, or something that, you know, oh, they were supposed to get this fixed and, you know, they gave us a receipt of some sort, but now things are in question because maybe that receipt was not exactly what it should have been, etc. A lot of our clients come to us and they're like, you know, oh my God, what do we do? This has just happened. So recently, one of my clients actually lost water, no water in the house whatsoever, 8 hours after closing. And, you know, they're looking at me and I'm going, you're gonna have to talk to your lawyer. And a lot of our clients immediately go back to the lawyer that did their closing. And what I've noticed, and I don't know if this is across the board or just with the lawyers that my clients have picked or whatnot, you know, kind of at that point, the lawyer's kind of like, well, you know, we kind of stop at the closing. Is that really the case within the legal field of real estate transactions? does your guys' job kind of stop when title is transferred? And then what are we to tell our clients after the fact? Because a lot of times we've just kind of said, well, go back to your lawyers, and then the lawyers are like, we really can't do anything for you, you know, go to small claims or something. I kind of feel like people lose trust in not only our professionalism, but then the lawyer's professionalism, like they were scammed somehow because we just did the deal and then tossed them aside. What was a lawyer good for in their heads, right? So what is your position on that? And really, what should we be advising our clients about a situation?
It's a good question. The transaction itself ends after the closing in some senses, in that the fees that we charge are based on from the beginning of the review of the agreement till the closing day and it's closed. And if there's any holdbacks, we might address those. But that's technically the transaction itself. Having said that, it'll depend on your lawyer how they handle it after that, because if there's issues, I'll try to negotiate initially with the other lawyer, but there's really no obligation on a seller to come back with anything at that point, because they know that the only way you're going to guarantee to get something is to take them to court. Now, if we're getting into something more substantial, typically then my hourly rate applies. And so some clients won't feel all that comfortable to do that. Now, I'll have lots of conversations with my clients without charging them anything. But once we start putting pen to paper with letters that have to go out, which become a little bit more, they're more settlement letters, then fees go up, which clients aren't necessarily interested in depending on what the issue is. But some lawyers don't do anything litigation. So I've done litigation in my practice. I don't do a ton of it, only really incident to what else I'm doing and for my specific clients. But we do also in our firm have litigators. So sometimes if it's significant enough, it'll get passed over. So I've had clients in a very similar situation to what you're referencing, and it's being litigated, because really your closing day walkthrough is I describe it as your last opportunity to find anything wrong with the property. So I tell them to turn the burners on, turn the stove on, turn the faucets on, turn everything on. And to check any of those items that they say were done. Don't just rely on the receipt. Go see if you can check for them. And in some ways, I almost wish there was an inspector at the same time, but I don't think that's practical, in all honesty. But essentially, that would be my way of approaching it. And I have had lawyers come back to me after close and say, this issue came up. But of course, advising my seller client, I tell them do nothing. Because in a practical sense, the only way that to make someone give you money at that point is to go to court. Or maybe you can have a settlement if it's a very clear issue. So I guess it depends on what the response the client gives. Maybe they know they didn't have water and they hit it, and then I say, okay, you need to settle. So it would really depend on the nature of the situation. But it's not uncommon what you're saying about a lawyer saying, yeah, no, my job's over. Because there are lawyers who just are transaction based. They don't do any negotiation. They don't do any litigation. And it's really too bad. I feel like understanding how it goes from there is super important to doing your role while you're doing the transaction itself, because you want to make sure your client understands that it's not that you can't come back to a seller for misrepresenting something. It's that it's difficult to come back to a seller. And even in my own situation, I bought a house and I had issues later, and I could sue them and I know how to do it, but it's not worth my time. So that's the same idea that comes up with my clients if it's not significant enough. But that one does sound quite significant, and you could have a good chance of success if it was something misrepresented or hidden. Especially with the PDS, if it's incorrectly stated. I've seen case law come out that has ruled against a seller for something they didn't even remember had happened, but was actually on their Facebook page.
Nice. Well, yeah, I think the biggest thing I think we all have to, as realtors, have to do is, we always advise our clients, this is the PDS. If they ever say anything wrong on it, something happens, we use the word "you're protected," I think a little too much. And I think that we have to really advise our clients that although you do have this PDS, and although you do have these clauses within a transaction, within an agreement of purchase and sale, the minute that this house closes, the only thing, if those people are not willing to accommodate the concern, the only thing you have left is to go to court. And I feel like a lot of, agreed, we should be asking the lawyers' offices that we are dealing with, if something were to go wrong after the fact, are you a lawyer's office that will handle litigation, obviously at a cost, but still handle litigation? Because I find a lot of people, buying a house is usually, whether you've done it once, twice, or have never done it, it is not, it's not something that how to do. And that's why they lean on the realtor and they lean on the lawyers. And I feel like a lot of people lose faith in that because they're like, well, what were you guys all here to protect me for? You said I was protected. And then all of a sudden it closes, and I kind of think they feel like there's no protection at all, and they're left to their own. So I think some really big questions to ask the lawyer is, do you do litigation after the fact if something were to come up? And I think, just recommending that, although these things like a PDS and the clauses we put in our APS, are there for protection, they're not necessarily, it's not like a catch-all. It's not, well, if this clause is in there, that means that the seller has to pay for it. No, you have to kind of go to you guys and say, is this worth litigating, and have that advice. So
Yeah, it's tough because people do look at those property disclosure statements as everything. Like, oh, well, they said this. And it's like, well, they said this to their knowledge. And now you have to prove they knew otherwise, which is a hard uphill battle to do. If you've got no water, that might be able to, but how do you prove that that didn't just happen because it was, very sunny for the week and that was just a fluke? It had never happened before. So it's really tough for clients. And I think you're right. I think, I try not to say that I'm protecting them in full. I really try to reinforce the role of everybody in the transaction, and I send them back to people who can do those inspections, people who can look at something. If there's something that comes up on your inspection, maybe hiring a professional in that area to give you a little bit more information, which I'm sure you guys already kind of do a little bit of that, but that's something that they can turn to, is that you've got a professional who told you this is the cost to fix it, or no, actually this looks good. But that's tough. And small claims is an option for individuals to do on their own without a lawyer. So sometimes I will send a client that way because the cost to hire me to do it won't match with the cost to fix the issue. So I might suggest small claims in that instance. But yeah, it's tough. Absolutely.
Yeah, I think as long as on our side, our responsibility is making sure that the clients understand the process should things go wrong. I think one of our broker, Ann De Silva, always drills through my head, everyone prepares for the marriage, but they never prepare for the divorce. So prepare for the divorce.
That's great advice.
And the problem with the small claims court, I went into one a number of years ago, must be 10 years ago now. But I mean, we had the seller dead to rights. What he did was criminal, and he was hiding stuff. And it was an $18,000 fix. And the adjudicator said the PDS wasn't worth the paper it was printed on. He wouldn't let me say anything in the courtroom. And after 3 months of deliberating, he came back and and we had evidence like crazy, and he weighed in favor of the seller. So my client got nothing. And I was beside myself, and I just couldn't believe that they would do that. So
How
I
could
don't
say that
have any.
yes isn't worth the paper it's printed on, then why do we even do them?
That's what I asked too.
Yeah, see, I've actually had adjudicators go the other way. I have observed a situation where an individual had some water leaking into their property after they dug up and redone a septic, and they managed to actually blame it on the seller, even though what they did is when they put the septic back in, they didn't have the trench that redirected the water away from the house, but they managed to put it on the seller because back, I don't know, 5 years prior, there had been a leak following a really massive snowstorm, and it was determined by the adjudicator that was the issue. So I like to describe court, part of my language, as a crapshoot. You never know what you're going to get. So I hate to go to court. I much prefer settlement because I find that you don't win a court. You never win a court. Even if you actually win, you don't feel like you won. You don't feel like you got justice for what happened. From my personal experience, I find more clients leave happy if you can settle a matter than if you can have to take it to court. Having said that, Angela, you are right that having a lawyer whose firm can do the litigation, can support the client still feels like their lawyer is taking care of them is important. It's something that I wish more firms did.
Yeah, it's definitely something that, and although over the years, small things have come up and, these are the questions that we kind of look at each other and go, that's right. Right. And the thing, I wonder if our lawyer's office does that, but, we really have never asked. So I think, we, within our team, I think we use a number of lawyers between all of us. And I do think it's a really important question that we all go back and at least we know whether we want to keep using that lawyer is fine, but at least we know, what it is our lawyers bring to the table should something happen.
Now, I will say in fairness to the lawyer who maybe doesn't have that internally, there are some smaller firms that don't have that, but they may have a very strong connection with a lawyer at a nearby firm and can contribute to that transition over to another firm. So before you write anyone off, in fairness to my colleagues at the bar, I would just say make sure you find out who they might work with if there was a situation, just if you're going to look at that.
Definitely. There's nothing that great referral, right? So.
Any other questions?
I was going to say after my experience in that small claims court, I believe in talking it out. The two lawyers can usually come to an agreement, but if they can't, I'm a big proponent of a letter from our lawyer. The letter has more weight than going to small claims court a lot of times, I think. So that in question, Amanda, what would you charge to send a letter to the other lawyer?
Depends how much the client's looking for in a letter. Typically, it's a couple hours of my time, so around 500 plus tax, roughly. Depends though, because if I'm doing a full settlement letter, which could require some case law research, it could be more. But most clients can get it in in and around the 500. I'm getting faster at typing, so it might be a little less than 2 hours. But I like to roughly estimate about $500 so the clients are prepared. Court, you're talking probably starting more like 10 grand. So $500 doesn't sound like a lot when you're talking 10 grand for court. So certainly that's a little better. And yes, you're right. A very well worded letter can make all the difference. But if the other side also has a lawyer, sometimes that doesn't go so hot. So we have some that have gone through small claims, even with a lawyer, and I myself, I'm looking at it going, this is so obvious and so egregious. And yet I'm nervous that when the decision comes down on a particular file, that it's going to go the same way yours did, Michael. And I won't be a happy camper.
I have a question regarding the holdback clause. So I transferred from Ontario. Don't really use holdback clauses there, so they're new to me. Can you kind of explain them from a lawyer perspective to me? I think I have a really good understanding of them, but can you explain? My understanding is essentially that it allows the sale to still close if some repairs are not completed, just as a general statement. Is that accurate?
Yeah, so there's a few different things when we talk about holdback. So we'll start with the general holdback on closing. So there's a problem and the seller is going to fix it. And in order to do so, they have to do something that's going to occur likely after closing. So the parties agree on a holdback. When you determine what your holdback amount should be, you want to look at how much is it going to cost my client if they have to hire a professional to do this work themselves. Because the holdback should have two components. What's the amount and what's the deadline? So for example, let's say they were supposed to fix the dishwasher and there's a leak and you can see the leak still occurring. And so to replace a dishwasher, dishwasher, and I know this is not the amount, but let's say it's $1,000 to replace a dishwasher. It's going to be $500 to get a guy in to install it. So I'm going to want to ask for a $2,000 holdback, because it's not just about what's the cost to my client. It's also an incentive, because the reason my client's doing a holdback is because they don't want to deal with it. So you want to make sure there's something that incentivizes the seller to actually complete the work, and then those funds are released to the seller at that time. As for who holds it, just for a side note, because people ask me that all the time, it doesn't matter to me which side holds it. If the other lawyer is holding it, I would just ask for their undertaking to hold it until I tell them otherwise. So those are kind of the most common holdbacks. And you would do a holdback instead of a credit, because ultimately the seller is going to be doing the work, whether it be someone they hire to come in or not. There is two other holdbacks that I should probably mention, and that's your builder's lien holdback and your deficiency holdback when you're dealing with a turnkey property. Those are actually really integral, and people don't quite recognize that. You might have a fantastic builder that you're working with, but I have to assume that every builder is horrendous. That's my job. Look at all the horrible things that can happen to someone. So when you get to your closing day, especially these days, it seems like there's always something that's missing. Countertop didn't come in, or shower doors not being installed, and those are substantial costs to a client. So builders do not like deficiency holdbacks, because when you agree to a deficiency holdback, technically the buyer's lawyer has to say, yes, you can have the money. But the buyer's lawyer cannot say, yes, you can have the money, unless their client says, yes, release the money. And if the client has now moved into the property and they're looking at the walls and they see a ding over here and a little nick over there, they can consider, oh, well, the work's not done, so they won't let it go. So that's why builders don't like it. But if you have reasonable clients, then realistically, a holdback is the right way to approach that for deficiencies, so that if your client isn't saddled with the cost, if the builder never shows up to complete. And I'm sure we've all heard some horror stories there. The builder's lien holdback is a statutory obligation, and although there's a few builders who have a small exception to that, effectively it's held back 60 days following completion of the property, but then there's actually another further 60 days. That builder's lien is an obligation unless there's an exception. So if someone's writing it out, there better be a reason. So those are just a couple different other ones I just want to mention just as an aside. But the big one I think you're talking about, Joe, really is that holdback on closing because of an issue.
Amanda, what about a holdback for something that's not a deficiency, but it is the winter and you can't examine the pool, and you have no idea how much that may cost if there's something wrong with the pool? What do you do there?
Yeah, that's a tough one. I don't like those ones at all, because it's hard. You're right. How do you even begin to have a concept of what that's going to look like? Certainly you can get a sense of what the major issues are from a professional who does that, and maybe you can agree to a holdback on that. But that's a tough one. And I've certainly seen it where we had to push a closing because we couldn't check that the pool was in fact in working order. And unfortunately, a holdback was only going to go as far as the amount of your holdback. And a seller is not going to really want to hold back, I don't know, $20,000 to put a new pool in, whatever it's going to cost them, because that's really the only other way to do it would be to have a substantial holdback. Now, I don't know if a pool company or someone who would inspect pools would be capable of doing so even in the winter if it was able to be uncovered. I'm not sure. But certainly that's a tough one, but a very good question. But ideally, what you'd want is enough to replace it. Whether a seller is going to agree to that is a whole nother ballgame.
Yeah, because I mean, essentially, what if those sellers need those funds to transfer to their next property? They're not going to allow a 20,000 holdback on money that they're required to use for their buy.
Or if there's 3 other offers on the table, and like this kind of a market at like, if you're asking for something like that out of the gate, like if there's 2 feet of ice in the pool, like, and the other person isn't, good luck getting it.
Yeah.
Yeah, it's really just something your client has to decide on the risk they're willing to take, because exactly what you're saying, Alex and Angela, is that 20,000, no, they're not going to agree to that because they might need it on the next home, or even if they don't, no one wants 20,000 tied up for 6 months. And it could be that long in this area. And the other problem being, you're right, if there's backup offers, if you come in with that as a clause, how do you even address that? So whether someone would actually agree to accept your offer in that case. So I guess it's something your client has to decide. Are they willing to take the risk that they're not going to be able to determine if it's right, if it's in good condition. And some issues can happen just over that one winter. So it's something you may not even be able to litigate against the seller because they wouldn't have known either until they open it up for the summer. So it's definitely a risk, and it's really something to just make sure your client truly understands if they're getting into that situation.
Yeah, pools are a hard one. I think that pools are kind of, especially in our climate, they're, I don't want to say they're kind of as is, but I mean, a pool over the winter time, anything can happen. So I don't put a whole lot of weight into swimming pools. I really will, like, personally, I tell my clients that anytime that there's something to do with a swimming pool, there's always going to be more risk than, a stove.
Amanda, I had an issue a few years ago, which is interesting. It was with a builder that I referred to as awful contracting. And a year and a half after my people moved into their new construction home, they get an eviction notice from the city because they had no occupancy permit. So the question was, like, whose responsibility is it to get the occupancy permit? I know with new construction, sometimes you could be waiting maybe 3 months. And I certainly didn't go back to find out whether or not they had an occupancy permit.
I've heard
And,
this as well, Mike.
Yeah, this is one of the worst ones, and it makes me very angry because I know that builders want to close, they want their money. Purchasers want to purchase because they see the house already built and they want to move in. But the legal right to live in a property doesn't exist till you have your occupancy permit. So technically speaking, they are well within their rights to kick you out, even though you have your final inspection report says absolutely you're getting your occupancy permit. But there's a lot of builders that will not hold any money even. We used to hold the builder's lien holdback, and they changed the contracts in your most recent iteration to separate out an occupancy permit holdback, and then every builder writes out the occupancy permit holdback. So you tie our hands, and what are we to do about it at that point? So what I do, just personally, is I get title insurance. Title insurance will cover you in those instances, in those cases. Now, I can speak really only for Chicago Title, who we use, but essentially Chicago Title says that if you don't get an occupancy permit, and as a result, you have to bring the house up to code in the current standards, or if I'm guessing, although I can't specifically say, but I would assume that it would also cover a situation where you're forced to move out for that reason. The title insurance would cover the costs associated with it. So for a rather inexpensive policy, it comes in handy for that. So that's the first thing, is if you're going to accept that, you better get title insurance. But I explain these risks to the clients because, frankly, and this is my opinion, they really should not be closing without an occupancy permit. But I also acknowledge that our municipality is taking 3 to 6 months to get an occupancy permit out. So it could sit there empty, no one living there for 3 to 6 months, which has its own risks as well from a builder standpoint. So I certainly understand why they do it, but that is a risk. And the only way I can think of to help protect my client is holding back money to make sure that the builder actually provides it, or title insurance, ideally both.
Can you, there's title insurance is one of those things that a lawyer will always say, oh, get title insurance, that covers you. Can you explain to everybody what exactly title insurance is? Because when I was a newer realtor, I was like, oh, it covers you. If anything happens, it takes care of it.
So title insurance is a policy of insurance. It protects you from things you couldn't have known when you bought the property. That's probably the easiest way to understand it. So it's all very fact specific. So if it's something you knew, so the PDS is a really horrible document sometimes, because I don't know if you guys noticed, but in there's a nice little line that says, have you obtained the necessary permits for the work done on the property? I hate that question, because most people will say no, because what they mean is, no, I didn't need to get any permits to do the work. What they should have said is does not apply, or yes, because they got everything they needed. But when they say no, that's knowledge. So if I'm talking about something that you didn't know, you couldn't have known, then if you've got a PDS that says, no, we didn't get our permits, well, then you're out of luck. So title insurance is very fact specific. So it does cover you from a lot of different things. It covers you from failure to obtain permits, so occupancy permits, and it also depends on the property. And it covers your lender from a heck of a lot more than it's going to cover your client. So the lender gets coverage for septic and water, but your client does not. So those are some examples, but it's really fact specific. The biggest thing it also covers is encroachment. So if it turns out your house or your shed is encroaching over the property line and your neighbor comes to you and says, you must fix this. So not just you finding out about it, but your neighbor telling you you have to fix it, then title insurance can cover the cost. But it's not a catch-all. It won't do everything for you. And it's so fact specific that I can't even say to a client, yes, this exact scenario is absolutely covered, because honestly, I won't know for sure.
But you're required, sorry to cut you off, Amanda.
Okay.
You're required as the buyer, seller, whatever, you're required to go take care of that stuff and then submit it. And then title insurance will possibly cover some of those expenses. It's not like, you know, you step in and you say, oh, they're saying that I have an encroachment. You're going to take care of that now, right? It's not quite like that. Is that correct?
It depends. So my title insurer said, if you have an issue, start by calling me, because I might cover it, and then they might prefer to step in and handle it, as opposed to it having to go through like you pay for hiring X person to do Y job and so on. Sometimes they actually prefer to do it themselves, which could also include cutting part of the shed off. And I'm not kidding you. I know you're probably dying inside, but yes, quite literally, if it's cheaper to cut half your shed off because it's over the property line, that's an option. And then they'll credit you for your loss of value, not in full, but a certain amount, indemnity. But so I always get them involved at the beginning. At least my title insurer that I work with, that's their recommendation to us, is to tell clients to call us first. So whenever a client calls me with an issue, I say, did you call title insurance? Because I would much prefer title insurance to cover the cost for them at the outset, instead of them having to eat the cost and then hope to make a claim. Often you can get title insurance to confirm for you if they'll cover it. And I've had even foundation cracks covered. Again, that was a rare instance, but it, in whatever reason, it happened. I don't know if that answers your question.
Amanda, while you're on that subject of title insurance, would you just expand on that again about where they would do more for the lender as opposed to the owner in regard to water and septic?
Yeah, so title insurance has well and septic coverage, and it covers certain issues that can come up because the lender never actually attends the property. They're not going to come down to the property and go, oh, look, the septic inspection went lovely, and they look at the septic inspection report and do all that. So as far as title insurance is concerned, an owner should be doing that, but they're never going to expect a lender to walk out of their ivory tower and down to the septic tank and say, oh yeah, look, it looks great. So they'll cover more issues that can come up with the lender side of the world. So if a lender down the road ends up foreclosing, it's probably the best way to understand it, and then they now have to deal with an issue that's come up, then that's a situation where they can potentially utilize title insurance to cover them, instead of having to pay out of pocket to fix the issue and sell the property and lose the value in the property. So that's part of why some lenders require title insurance, and it's not even a question as to whether or not I get it. Whereas other transactions, I might have a choice. I don't know if that kind of answers your question, Michael.
Mike, you're muted.
Thanks. You wouldn't have to wait until they foreclosed on your house, would you?
The lender might not. I don't know. I can't say I've ever seen it actually used prior to foreclosure, though. So what I mean is that your lender may not need to use that clause or that policy until a foreclosure situation, whereas otherwise it'd be you yourself. So for example, you find out your well doesn't have any water in it. The lender might have been covered for that, but you won't. But you can't then say, oh, lender, would you please get your title insurance policy to cover this? Because that's kind of a backhanded way to get it covered for the owner. It's really more than down the road if the lender takes over the property and now it's their problem that has to be dealt with, in which case my understanding is then title insurance would step in. But there are certainly situations, I can't think of any, but I can imagine there might be some where a lender might be able to use their policy without that.
Thanks.
Did want to mention one thing that I thought of on the title review side of the world. So one of the questions that was asked is, what are things you can catch before you have an offer before you have conditions and you're working through that. Migration is a big one. For those of you who aren't familiar, migration is basically the process of moving the property into our new land registration system, which I still call new, even though it existed in 2004. But there are still plenty of properties that haven't been migrated in, and I see a lot of problems that happen when the migration is done during the transaction. I've seen at least 3 deals fall through because the migration had issues, and there went the transaction. Personally, I would say have your clients migrate before you list, because I've had situations where they didn't even own the property. They listed, they had an agreement, and poof, for like a week before closing, all the costs associated incurred. Nothing my client could do about it. They don't own the property. They've been paying taxes since the 80s, but they don't own the property. So my best advice on that is, if you see your property that you're going to list is not migrated, send them to the lawyer and get it migrated as soon as possible. At bare minimum, get the lawyer to have the title search so they know what problems are going to have to be dealt with, including, are they the owner?
How long does that process take if it's, I actually have a sale that's closing in about a month and the property was not migrated?
Depends on the property. So I usually say a minimum of 2 weeks to migrate, but I am expecting to do one today and tomorrow and complete it. The biggest length of time is waiting for the title search. So some lawyers will do it themselves and they charge an arm and a leg for it, because my hourly rate at $250 an hour, I'd spend a heck of a lot more time than my title searcher, who's much less expensive. So I wait for my title search to come in and then I review it. And that title search tells you basically what problems are there. So is everything straightforward or not? So if everything's straightforward, easily, a week, as long as the government feels like working, because there's steps that I have to do with the government where I submit the description, they'll review it and tell me if they're okay with it. And then I submit the details of the property and they tell me if they're okay with it. And then I finalize. So because the government's involved, they get minimum 2 days for every step that they do. And so certainly on my side, I also need some time to work on it as well. So I usually say about a couple weeks for myself. Having said that, if it's complicated, it can take months, because we could be getting into a prescriptive situation where we have to prove ownership of the property because it's not correctly documented. The handshake deals back for pre-2004 are still haunting us today. So those are often the bigger problems. I don't know if that answers your question.
Sounds like I need to contact the lawyer involved and check up on it. Thank you.
No problem.
Amanda, I heard a lawyer one time say that during the migration process and registering, it's probably the one time when legally you can steal your neighbor's land. So how does that work?
It's not during the migration process per se. Technically, you can migrate something into your name that turns out it wasn't yours, but that'd be difficult. But let's say, for example, the situation happens where they don't actually own the property and your neighbor does. When your neighbor goes and figures that out, they can migrate it into their name. So I guess that would be, quote, stealing the property. But technically speaking, it's because they have clear title that shows they're the owner. If you haven't migrated your property, there's a chance that someone can make a prescriptive claim against the properties or squatters' rights. So they have to have, for standard land, they'd have to have like 20 years of continuous open and notorious use, which is going to be a hard bar to meet, but certainly people can. If it's crown land, you're talking more like 40 years, so that's even harder to do. But you can prescriptively show ownership of the property, but those are super risky because you're going to need a couple people who are disinterested parties who will swear that you've actually used that openly, notoriously, continuously without permission or prohibition. So there's a number of factors, and trust me, it's costly. But having said that, pre-migration, you can do that. If someone migrates their property today and a person had been using their property for 19 years, then you stop that clock. They can't get the 20 years because that migration has occurred. But if someone did have 20 years continuous use, then once that migration happens, they have a certain length of time within which they have to bring that claim. Now, if you know of the prescriptive use, you have to give notice to that person. If you don't know the prescriptive use, then there's a 10 to 15 year time frame. It's technically 10, but judges have interpreted to go to 15 so far. I'm not going to bar any judge from coming up with a longer time frame, but that's what we work off of. that someone could still bring a claim for prescriptive rights. So the other thing to think about is if you've got a client who's just migrated and selling and your client's purchasing, there's a chance that 10, 15 years down the road, someone comes back and says, hey, you don't own the property. And there's why we get title insurance again. Sorry, does that make sense?
No, that's great. The lot next to me is owned by an alcoholic, and he keeps on talking about building a house there. And he's got a hedge that's probably 5 feet from my property line that I've been mowing since I've owned this house for 20 years, and people before me mowed before that. And I thought, geez, if I had it migrated and took that 4 feet, he wouldn't have enough street front to build a house, and he'll never be my neighbor.
You might be able to make that argument. I'd have to look at a lot more facts, but you might be able to make that that argument. Anyone have any other questions?
I'm just looking at the time and wanting to, I know that life is busy for you as well. And we really appreciate you taking the time to come and to be with us today. So Amanda, huge thank you from all of us that were here and for the agents that will be listening at a later time when this is posted for our group. But we certainly know that that you guys play a crucial role and a pivotal role in all of our transactions. So thank you for your wisdom and your teaching today. And yeah, we just appreciate you taking the time.
Yeah, no problem.
And do you, I know Renee has your contact info. So if anyone would like to reach out to Amanda, Amanda, if you want to throw it up in the chat there. Your contact info, and if you don't get it, then you can certainly get it from Renee as well, or from Aaron. Should be able to have that as well. Oh, there we go.
Oh,
perfect.
Sorry, I mistyped. 1 sec. We just changed our email addresses. Sorry. Okay. But yeah, if anyone has any questions, please feel free to reach out to me at any time. No charge. I'm happy to answer questions. Just give me a call. I'd rather you be able to support your clients the way you need to than be unable to answer the question. Because sometimes you just really need to banter something with a lawyer or discuss it with them. So please, any of you, if you need that help, please reach out. I don't mind at all. It doesn't have to be my deal. I don't care. I'm happy to help. Okay.
Perfect. That is great. Thank you so much. And yeah, everyone stay safe today. And if you're on the roads, drive safe, please.
What's happening in Halifax right now, weather-wise? I'm in Cape Breton, so.
Pouring rain where I am in Fall River, and the wind is some really good gusts.
Okay, it's snowing in Cape Breton, in Sydney right now.
Okay.
Yeah. Okay, be safe. Thank you.
Thank you very much. Thank you.